I'm told I have 40 minutes. I try and wind up my talk about 25 minutes so that we have 15 minutes for questions and answers. Since it's a vast subject, what I'm going to do is, I presume that all of you broadly know what contracts are. I also presume that you know what intellectual property is about and different kinds of IPs there are. So I'll be briefly touching upon them. I will try and speak to you about practical aspects of how to draw contracts, what are the key features that you should look for in a contract when you draw in various IT situations, and which can protect and enhance the value of your IP. Okay, contract briefly, any legally enforceable agreement is a contract. Okay, there will be many agreements, but for instance, there will be an agreement with a friend to go to a movie together, but that's only a social agreement. But only a legally enforceable agreement is a contract. So these are the various components of a contract. All agreements are contracts if they are made by the free consent of parties. So if somebody is forced into a contract at gunpoint, or by an inducement or by misrepresentation, then there is no free consent there. It cannot be a contract. Competent to contract. So a person has to be age of majority, over the age of 18 years. The minor is not competent to contract. A person who is mentally ill, who cannot understand the circumstances of the facts which are leading to the contract, may not be competent to contract. So competency to contract is important. For a lawful consideration, okay, there should be a consideration for every contract. There should be, suppose you are, let's say, a software development contract. A company A agrees to develop a software, let's say, for the payrolls of company B. Then the consideration for it will be in terms of, let's say, 25 lakhs of rupees or 10 crores of rupees. That's the consideration. Okay. So a contract which does not have consideration is not a contract. That is why, for instance, even if in real estate agreement, sale agreement, the property may be worth, say, 10 crores, but in the agreement at least 1,000 rupee advance is given. The consideration can be very small, no problem. But there should be some consideration. If there is no consideration, then that is not a lawful contract. Now, the consideration should be lawful. Okay. So, for instance, if I say that I will allow you to into an illegal casino in India, in some corner of India. That's not a lawful, because gambling is outlawed in India. It's an illegal consideration. So the consideration has to be lawful. Okay. Then with a lawful object. The object of the contract should also be lawful. For instance, if it's development of software, it is lawful. But if it's development of software for an illegal purpose, let's say again to run a casino or to run a trafficking racket, then that would not be an enforceable contract. Okay. So what are the various kinds of intellectual property? You all know, I assume, copyright, trademark, patent, trade secret, confidential information. So copyright covers typically expression of an idea, not the idea itself. Before going into software, let's look at copyright alone. Typically, artistic works, dramatic works, literary works are subject to copyright. In IT, all software, most software is copyrightable, provided there is some originality to the software. Okay. The Copyright Act itself says that copyright protection extends to software. Trademark is a badge of origin. Okay. Typically, for instance, Windows is a trademark. Microsoft is a trademark. All your the companies or business entities that you have, your names will be a trademark. Okay. Now, trademark is not compulsorily registerable. Okay. But it is advisable to register it. Even if you do not register it, if someone infringes your trademark, then you can go to court and say, if you establish before court that you have been using the trademark for a long time, and in the market the trademark is associated with you, then the court may grant you relief, either injunction or compensation. But it is always prudent to register a trademark. Similarly, so is it with copyright. Copyright is not compulsorily registrable. If you write a poem or develop some software, it is sufficient if you say copyright of so and so, all rights reserved. Then that is an attribution, that is a notice to the other party who is using the software or the copyrighted material that this is copyrighted material, and you will have to get prior permission to copy it or sell it or deal with it. We just deal with trade secrets and go back to patents. So, trade secrets and confidential information. I'm sure most of you here have signed non-disclosure agreement or got others to sign it on, for you. Confidential information. Now, confidential information and trade secrets are material which are not in public domain. If they are already in public domain, then although you may style it as confidential information, it is not confidential information. Okay. Now, how do you determine? Suppose there is in a court of law, I am working in X company, and then I go to Y company, and I disclose something to them. X company says I have disclosed this trade secret to their competitor. Okay. Now, how does the court determine that? To determine that, the court will have to see, one, whether the category of what I am claiming as trade secret or confidential information is clearly defined. The boundaries are clearly defined. Second, whether I have informed all the stakeholders, particularly my employees and consultants, that this information or material that I am sharing it with you is confidential information. Third, whether I have taken necessary steps in order to create a security barrier around that confidential information. Suppose in an IT situation this could mean, suppose this confidential information resides in the company server in a particular folder, whether that folder is accessible by everybody or only by a few people on a need to know basis. Now these are all the elements that a court would look at to identify and classify something as confidential information or not. Okay? So when you are looking, these are some of the things you will have, these are 3 or 4 steps you will have to take if you think that some information or secret which is in your possession, which is valuable to your business, is a trade secret. Now to patent. What is patent? Patent, as all of you know, is granted as a limited restricted monopoly for a period of 20 years for an invention. For an invention, what is an invention, or when does an invention qualify for a patent? There are 3 criteria. There is something called NUN test, N-U-N. Okay? N, the first N is novelty. Okay? It has to be new. So, what is new? What is not old? Okay? So, what is old? The technical term used for what is old is prior art. Okay? P-R-I-O-R. ART. So what is prior art? Prior art has 2 components. One is what is in prior use. Suppose I claim that I have invented this wireless microphone, and I bring it here, okay, and say this is my invention, and I file a patent for it today. Now, if I file a patent for it today is the date of priority, okay? So, today is the date of priority. Now, when the patent examiner examines whether this is new or not, then, then what he will do is, he will look at all the prior art, by which is meant, one, whether there is any other loudspeaker, like, microphone like this, which has been in use in any part of the world prior to this date. If it was used by my friend in a public meeting yesterday, then patent is barred. Okay? But if it is used in an experimental situation, patent is not barred. Prior use. Second is prior documentation. Let us say I had a team of researchers to work on this wireless microphone. And one of the researchers attends a seminar last month in IT Research Park. He is very pleased with himself for having been part of this invention team, and he begins to boast about his invention and before a team of scientists and say, this is what I have done. And then there's a slideshow on all the features of this, disclosing all the inventive elements of this. Then a patent is barred because there is prior publication. Okay. So therefore, to qualify for novelty, it should not be prior art, by which is meant it should not be in prior use, there should not be prior publication. Okay. The next is utility. What is utility? Something which is useful. Suppose I create a new kind of sculpture, a beautiful sculpture of a microphone. Okay. Now that is not useful. It may be beautiful. All of us can look at it and admire it. So therefore, that may qualify for copyright as an artistic work, but it does not qualify for a patent. Okay. That's straightforward. But not so straightforward when it comes to software. We come to that later. Okay. Then the third is the most important and difficult to understand. It is called non-obviousness. Non-obviousness. N-U-N. Okay. In India, we use a different term to talk about non-obviousness. That is inventive step. Inventive step. Okay. What is inventive step? Let us say there is a 4-leg chair. Okay. Now all of us have seen chairs with 4 legs. Now I decide to create something new. I create a chair with 12 legs. How many of you have seen a chair with 12 legs? None of you. So it's new. I don't think there's any documentation about it. Okay. So, but does it qualify for a patent? Do you think a 12-leg chair can be patented? It does not qualify, as you say, because it is new. It may be useful because it may be more stable than a 4-leg chair. But it would be obvious to a person skilled in the art. Any skilled carpenter will tell you that if there can be a chair with 4 legs, there can be a chair with 6, 10 or 100 legs. There is nothing inventive about it, it's obvious. Okay? So it is not enough if an invention is new, but it has to be non-obvious, which means it should not be obvious to a person skilled in the art. Okay? Now every item of or species of intellectual property has a dramatic character in it. Okay? In a patent, it is a person skilled in the art. In a trademark, it is a person average consumer with imperfect recollection. So for instance, if there is a suit for trademark infringement, and let's say there is Sanola oil, I create something like Sapola and start marketing it. Now Sapola may say it's totally different, you are using N and it's there. But the court will see whether there is anything deserved to be similar, either phonetically or visually. Now you see a Sapola package. If the package also resembles visually a Sanola package, then I may go and pick it up. Okay? So because when you are looking at a shop shelf, you don't look at it closely, you just pick it up on instinct. That is why in a trademark, the dramatic person is an average consumer with imperfect recollection. Whereas in a patent, it is a person skilled in the art. Now, let us say, in the case of pharmacology invention, for instance, let us say somebody comes up with a new drug and he merely replaces a mesylate salt with a mesylate salt. Okay? Now, I say this is new and inventive. It may be new, it may be useful, it may have great new therapeutic properties, but the court will not grant a patent, or rather the patent examiner will not grant a patent, because any average chemist or pharmacologist with an M.Pharm degree may be able to try out, oh, this is a mesylate salt has been used, let's use a mesylate salt. So therefore, there is nothing inventive. Why I am giving you the second example is that a person skilled in the art can differ from one art to another. So in one art it may be an average carpenter, in another art it may be a guy who is PhD in nanotechnology. Okay? So these are the persons skilled in the art depending on the art. So now coming to software. Section 3K of the Patent Act says software 3K. Okay? Then software per se cannot be patented. Okay? Per se is P-R-S-E. It means by itself. Mere software cannot be patented. So many people, including several examiners, there would say in India patents there cannot be any software patent. It is not quite correct because there have been software patents granted. I come to that shortly. Now, therefore, under section 3K, there is a what is called as a subject matter bar to software. If it is even if it is novel, useful, and inventive, pure software cannot be patented. What is pure software? Let us say something like Tally, okay, or a payroll solution, or even an ordinary ERP. You may not be able to patent it. When can software be patented? Now, it may not be untrue to say that in today's technology context, if software cannot be patented, nothing in the world can be patented. I'm sure many of you came by cars today or some motor vehicle. From your accelerator to carburetor, there is some software working, isn't it? So therefore, today, much of technology is either software assisted or software enabled. Okay? So therefore, it is a myth to say that software cannot be patented. I'll give you one example of a software patent that we have filed. We filed a patent for a software-defined base station. See, in mobile telephony, the signals are generated and they go through vast distances. And since there is a different signals, you need base stations to amplify the signals along the way. Okay? And wherever there are base stations, adequate base stations are not there, in those areas signals are weak. Now, typically a base station will be half the size of this room. Okay? Now, one of our clients, a small company in Bangalore, has come up with a software-defined base station by which they have reduced the size of the base station to the size of about 2 fridge stabilizers, something like this. Because a lot of functionality of the base station is taken over by the software. Okay? So therefore, this software, apart from being miniaturized, saving great space, it also allows for remote upgrades and remote maintenance. Suppose there is a base station up in some hilly area in the Himalayas, very Gedwal. What the technician has to run up, go repair it, and it takes days. Whereas this admits of operating from remote location and upgrading it, and there are many other features. Therefore, I believe that this software-defined base station is patentable. The Supreme Court of US in Indri Bilski case has held that ordinarily a software can be patented if it passes the test. It's called machine transformation test. Okay? If it transforms a machine or a hardware into performing certain functionalities of an enhanced character or of a novel and inventive character, then that can be patented along with the software. Okay? And transformation is if there is a software which transforms a material. Suppose in a chemical context, there is a material which is visible to the naked eye, and there is a software-enabled process which transforms it into nanomaterials which have widely different properties. Today nanomaterials are used everywhere with enhanced properties. Okay, and then it is patentable. Okay, so therefore this is a situation in which software can be patented. Okay, this I have already dealt with, but in an IT context, patent broad protection for a range of implementations of an innovation. I have already spoken about this. Copyright protection limited to copyright of expression. As I said, an idea is not copyrightable, but the expression of an idea is copyrightable. So there can be 2 or there can be 100 varieties of billing software or payroll software, which can each of which can be copyrighted. Okay, then it does not prevent others from independently developing same idea. Primarily a tool to prevent piracy, reproduction of entire work or key component. Not very effective at preventing cloning or duplication of features. Okay. Whereas if you see patent gives protection to the functionality itself, whereas copyright is merely to the expression. Trade secret, again I told you, trademarks. In the software context, you get, for instance, user interfaces, your windows, some of the icons you use, all those can be trademarked or even copyrighted as artistic works. Just a small cartoon for you. This guy was caught stealing office supplies, but the guy who was caught stealing ideas under the guillotine in today's context. This does not mean, it's not merely about a person, but a business can face this if you steal ideas of others. So these are the various areas of various processes which are important when it comes to intellectual property. One is protection. Okay. So protection typically can be two kinds of protection, which is legal protection. Ordinarily, you register a patent or you register a copyright or a trademark. The second is technical protection. Technical protection is, suppose particularly in the IT context, if you are disclosing, let's say you are dealing in different photographs, you are selling photographs online. If you merely say this is copyrighted, then it does not prevent people from stealing. But if you can have a function by which the copy and paste or cut and paste feature is removed from that website which displays photographs, then that is technical protection. So we encourage people to have both protection, both of the legal and technical things, because that offers comprehensive protection. Infringement. So infringement issues are very important. When suppose you are publishing something or you are developing a software and releasing it into the market, you need to be concerned not only about protecting your software or protecting the proprietary aspects of your software, but first you need to see if you are infringing on other people's copyright or patent, for which you need to do a copyright or patent search and first see if you are infringing on somebody else's IP. Second, after having eliminated that possibility, then you try and protect your invention. See if it's new. Suppose you find yourself infringing, then the door is not closed. Then you can further develop it beyond what exists so that you create something new. Okay? So, thirdly, everything new is not IP. So, IP generation is about looking at the legal aspects, legal components or aspects of a particular IP and see whether you have generated IP. So typically if you are working on a patent, you are working on in any area, whether it is a software or let's say you are working on a new kind of a lens for a camera, then you do a prior art and see what are the existing state of art in lenses and how your lens is new. And if you find someone you have come up with a lens which already exists, the way of doing something new is to examine what are the problems that are there in that lens and then try to do some more research to resolve the existing problems in the prior art. Sharing, okay? I was just saying that ultimately IP is not merely monopoly. See, IP of course is legally restricted monopoly, but unless you share it with others and there is collaboration among different stakeholders, IP does not make sense. Okay? Because if you are an inventor sitting in a room or in a lab, unless you have people who can take you to the market, unless people who can get you facilitation technology. Today, whatever you invent may not be, suppose for instance, if you look at an average mobile phone, a mobile phone for instance, like this has something like 300 patents. Now there may be a patent in a process that makes this camera work, or a process that enables me to link a picture which I have taken from using my camera and attach it to an SMS and send it. Now obviously that patent cannot be licensed in isolation. I can only make it go to the market if I deal with mobile phone handset vendors. You understand? There may be other applications. So you need to collaborate among different stakeholders and sharing is very important. And therefore associated with that is licensing. Licensing is a legal method of sharing. Okay, that's how I would put it. Now this is where the pitfall lies. When you are sharing, when you are taking, for instance, most software for instance is not sold. Okay, most software is licensed. Suppose I buy a book. After reading it, I can sell it to another person in a second-hand bookstore. okay, for half the price or quarter the price. But if I buy a copy of Windows, okay, can I sell it to another person after I use it? I can't, because that is licensed and I probably have to destroy that copy, okay. It depends on the licensing conditions. So unless you are aware of the licensing conditions, you would not know what to do with it. And licensing conditions are framed in such a way by the person who is licensing their IP to ensure maximization of profits, okay, or maximization of revenue in this context. And in the process of sharing and licensing, you will have to evolve contracts in a way that enhances the value or enhances revenue. Now there is a word of caution here. Everybody feels that you must put all kinds of restrictions and clauses so that only one person uses, and if the second person uses it, he'll have to pay extra or she'll have to pay extra. Now that is not a very good way of developing or framing a license agreement. You should also ensure that more people are aware of this product. See, all of you know, for instance, for every copy of Windows, legal Windows that is used in India, at least 3 pirated copies are used. Why do you think Microsoft is keeping quiet about it? It's not that they don't know. They go after people with deep pockets, but stay quiet. Okay, I know many lawyers offices have pirated software. We use open source to avoid piracy. But many lawyers office. The reason is that Microsoft wants people to become aware of Windows, be friendly, become dependent on Windows for 2 reasons. There are many Microsoft dependent products which they can then rent. And someday when IT is fully enforced, then everybody will be compelled to use Microsoft. In our office, I think about 5 years ago or 3 years ago, we switched to open source, Linux and LibreOffice, which has LibreOffice comes, LibreWord, open Word document is as good as your Microsoft Word. But in my office, there was a big resistance to use of that. In fact, we had to say nothing doing it, and we brought in somebody to tutor them. And then after some time, they adopted. Today, everybody is comfortable. So when you migrate to a different environment, it's different. So therefore, today, Microsoft has achieved some kind of monopoly by ensuring that everybody is Windows dependent. So you will have to look at that. Suppose you pack your licensing terms too tight, nobody will buy it. People may not be aware of it. Yeah. So these are the different types of contracts in IT. We have development agreement, we have license agreement, assignments, MSAs, NDAs, source code escrow. I think all of you are from IT, so I don't have to define this. All of you know that? So I pass on. Okay, now so I'm going to deal only with what are the aspects of contract, pitfalls in these kind of contracts which you should be aware of. Okay. Now when you are when you enter into a development contract with X, okay, there is a vendor who develops a contract for your exclusive use. One of the most important things, apart from the other aspects of the contract, and I'm only dealing with IT elements here, you will have to look at is the existing IP. See, you may be bringing something to the table, the developer may be bringing something to the table. Maybe you have a functional spec already, and you are asking him to develop a technical spec. Then the functional spec, the copyright to the functional spec is with you. You may have the layouts already with you, in which case the copyright to the layouts is already with you. It is good to define what is already your copyrighted material.